Hi folks, my name is Nastia Garadilova and this is the Onboarding Training Series for Enough's Enough programs. We're going to start with Title IX. I think this is a really important basis for all college and university work. It is the civil rights statute that has really rooted a lot of conversations about sexual assault and sexual harm in higher educational settings and indeed in all educational settings. So if you're not familiar with Title IX, I would really recommend reading up on some of the history. I'm going to touch upon it today, but it was not to make this too long and just kind of a quick overview. I'm going to really be as brief as possible and definitely encourage you to read up some more on some of what I'll be covering. So why is Title IX important? Title IX was a civil rights statute that was passed in 1972, and there has been a lot of conversation and a lot of kind of back and forth around exactly what it means and exactly who it protects and exactly what situations it protects folks in. And I know it's been in the press a lot. There's been a lot of organizing around it. So when you kind of go back to the bare bones of what does Title IX say and what is Title IX, it is actually just these 37 words. So Title IX says that no person in the US shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. You may have first heard about Title IX if you're less familiar with its context in sexual harm work regarding gender equity in athletics. And sometimes folks find it a little bit confusing. How is Title IX about sexual assault, but also about gender equity in athletics? Well, I always bring myself back to these 37 words. It's essentially protecting folks from discrimination on the basis of sex in educational settings. So really any school, K through 12, a private college or a university, a public big state university, is an education program receiving federal financial assistance. So Title IX has impact on all higher education and K through 12 schools. We're going to just focus on colleges and universities because that is who you work with in the Enough is Enough grant. But it's always important to remember that students, before they reach college and before they reach higher education settings, do have Title IX rights in school before then also. So when it comes down to essentially being protected from discrimination on the basis of sex, and that being the whole root of Title IX, it's a little bit clearer to understand exactly why so many things fall under this umbrella. So gender equity in athletics is one example, making sure that there are equitable resources for getting folks of all genders involved in STEM, science, technology, engineering, maths, fields. It includes protections for pregnant and parenting students. So under Title IX, a student cannot be discriminated against based on their pregnancy or if they are a parent. And then also sexual violence and sexual harassment, of course, falls under this. So because Title IX is a civil rights statute, a lot of the subsequent guidelines, a lot of the subsequent markers, floors, ceilings, goals that have been talked about regarding Title IX have come from regulatory guidance. So this means that no additional laws have been passed through Congress, but each subsequent Department of Education under each administration is able to essentially clarify exactly what they perceive and what they understand these 37 words to mean. So that's why there is sometimes a little bit of back and forth. Because one Department of Education under one president's administration might release a guidance saying X, Y, Z, and then the subsequent Department of Education might come in if there is a new administration and a new Secretary of Education selected, and essentially say, actually, no, we don't think this means X, Y, Z. We think it means A, B, C, and that is the standard we're going to be holding institutions to, and that is what you must comply with. So let's take a quick look at Title IX history to understand the waters that we're swimming in. In 2001, President Bush's Department of Education released a Dear Colleague letter and released a guidance on Title IX that covered sexual assault and sexual harassment in more detail than had been done before. So this 2001 guidance, not dear colleague letter, excuse me, this 2001 guidance covered a lot of the basis of what we now think of as kind of mandated Title IX requirements, talking about having a Title IX coordinator and essentially clarifying that sexual assault and sexual harassment absolutely does count as discrimination on the basis of sex and therefore is protected by Title IX. In 2011, the Obama administration released its first Dear Colleague letter on this subject, and it really went into a lot more detail and gave schools a lot more requirements and also a lot more clarity about exactly how they were responsible for protecting their students. In the 2014 Q&A document, they really parsed through some detailed questions that schools were struggling with. And we're going to talk about responsible employees, but one example is if a school was trying to figure out their responsible employees' responsibilities, essentially, and they're also hosting Take Back the Night events. The Q&A thought through what does a disclosure mean? What does it look like if a professor who is designated responsible is at a Take Back the Night event or a talk back or a speak out to support, and here's a student disclosed? Does that mean they must then go to the Title IX coordinator with what they have learned? And really kind of thought through some of these complex questions that schools were grappling with. Title IX is applicable to folks of all genders, and it also protects students regardless of their of where they're from, of their race, of their ability, of their socioeconomic status. In the past, Title IX has always been based on affiliation with the institution. And I'm going to talk a little bit about why that might be changing moving forward later on. In 2016, the Obama administration also released a Dear Colleague letter clarifying that discrimination on the basis of sex does include discrimination against somebody because of their gender identity or their perceived gender identity, essentially protecting transgender, gender nonconforming folks. So thinking through what does the protecting trans and GNC folks actually look like? What does it mean? What resources do folks have the right to? So that's where some of these debates around access to the bathroom of your choice have been housed under Title IX because of this on the basis, discrimination of the basis of sex umbrella. Now, in 2017, under the Trump administration and the Secretary of Education, Betsy DeVos, the 2011, 2014, and 2016 Dear Colleague letters were rescinded, and they put in place an interim guidance that was then in 2018 replaced by a Notice of Proposed Rulemaking. So essentially in 2018, they released a draft essentially of what they were working on their final rule and what they wanted it to be, and they released it to give the public, any advocates, individuals, organizations, schools, experts, etc., the opportunity to notice and comment, to submit public comments on this draft, and for them to take into account and if they would like to then make changes based on these comments and this feedback. Because the rule, the 2020 rule, did include this notice and comment process, it went through more steps of the informal rulemaking process than did the 2011, 2014, and 2016 guidances. This means that if implemented in August of 2020, this Title IX rule will have a lot more weight behind it. It will have essentially legally binding obligations rather than best practices. And that's the difference between a rule or a regulation and a guidance. So the purpose of Title IX compliance and Title IX guidance and regulations from the Department of Education, regardless of the administration, is really to set the floor to make sure that no institutions are going below the standard that they expect, below the minimum standard that they expect, which is why the amendments are able to happen, the additions are able to happen. This is being recorded in July of 2020, so I'm not sure yet if the new Title IX rule will be implemented in August. I'm going to talk about it at the end just in case, but I do want to give folks an idea of the history so that you can kind of get a gist of where this conversation has gone and some of the ebbs and flows and some of the efforts that have been made on both sides to shift the meaning of Title IX and shift the protections that it offers to students. So for further resources, I would definitely recommend familiarizing yourself with some of these guidance documents, with some of these Dear Colleague letters. The Q&A document has a lot of really good, meaty, student-centered ideas in there. Even the ones that were rescinded, I think, are helpful to familiarize yourself with what the standards used to be and what the expected best practices used to be, so that you can kind of really have a firm grasp of where schools have been and where they might be going. I do also want to talk about the Cleary Act. The Cleary Act is important and also has a lot of protections for students in place. I included the full name because I think that gives a good gist of what its original intention was. So the full name is the Jean Cleary Disclosure of Campus Security Policy and Crime Statistics Act. So essentially in memory of Jean Cleary, who was murdered on campus by an intimate partner. I'm so sorry, not by an intimate partner, by another student. The Cleary Act was passed, and it includes mandated annual security reports, wherein each institution has to release up-to-date and accurate crime reporting statistics to its community and every year to the public to make it publicly available. Under the Cleary Act, schools must also give timely warnings of crimes that have been committed on or around campus. Now, the Campus Sexual Assault Victims Bill of Rights has also since been included in the Cleary Act, and that includes requirements for disciplinary processes, student survivor rights, and also requirements for educational programming that schools must maintain. Campus Save Act was introduced in 2013. I'm going to be whizzing right through this because I know that there's a lot to cover and you don't need to get in too much detail, but depending on the outcome of the August 2020 Title IX rule, the Cleary Act could become more and more important. So if the rule was implemented, I would recommend that you familiarize yourself with some of these different requirements in Cleary as well. I'd like to talk briefly about responsible employees before moving to talk about the Title IX rule of 2020. So responsible employees are folks on campus, individuals on campus that have been designated responsible, which essentially means that if they have been made aware of an incident of sexual harm, stalking, sexual harassment, sexual assault, they must share what they know with the Title IX office. The purpose of this is to centralize information and to ensure that student survivors receive accurate information about their options, including reporting options, both in terms of local law enforcement and in terms of campus processes, also support options in terms of counseling and in terms of hospital care if they would like it. So that is the purpose of responsible employee designations. This is shifting a little bit, and this landscape is shifting as Title IX changes a little bit, or rather Title IX, the statute itself does not change, and that's important to remember, but the regulations and the guidance around the statute as that is shifting a little bit. But I still want to cover a few really key factors because I think that responsible employees will remain, and while designations might shift a little bit, I think there are some common musts. So it is incredibly important for all individuals that are designated responsible to know that they are designated responsible, to know what that means, and to be able to communicate that to the students that they serve. In some schools, all faculty are designated responsible, for example. Some schools, it's just heads of department, or it's just faculty who are advisors to students. Some schools designate students responsible as well. So if you're a peer advisor, you might be designated responsible. If you are a residential advisor, you might be designated responsible. If you work in an on-campus job, for example, in the dining room, and you're a shift supervisor, you might be designated responsible. Many staff, including deans, are often designated responsible. So it's really important when you're working with a school, especially if you're working with a student who is trying to figure out their options to get support, for you to familiarize yourself with exactly who is designated responsible on your campus. What you don't want happening is a student thinking that somebody they want to disclose to or somebody they trust is not designated responsible, for that person not to share that with them, and then for that trust to be broken when they do legally have to share what they learned with the Title IX coordinator. That can be really, really harmful for a student, particularly if they're not ready to share with anyone in a position of authority yet. Notice I use the word share. I think because mandatory reporting is a term that is used a lot and is very attached to law enforcement, I really recommend folks using share instead of report. It has a different energy to it, and oftentimes if students already have some distrust of the institution and of the Title IX process, it can be really overwhelming to hear that what you have just disclosed to perhaps a trusted professor or perhaps a trusted peer advisor or a residential advisor is now going to be, quote, reported to the Title IX office. So I think using share I've found to be a lot more successful, and responsible employees really have to be clear about why they're sharing that and what that means for the student in terms of moving forward. One of the purposes, like I said, is clarity of information, because not all individuals in a campus community know exactly what should happen after an incident of sexual harm or after being disclosed to. There have been quite a few cases of very well-meaning professors being misinformed and misunderstanding what they have to do, or kind of saying something like, you know, thank you so much for sharing, I have to report it to the police now. And we never, never want to take that decision away from the survivor and away from the student. So making sure that responsible employees know exactly what they're meant to do and why they're meant to do it, and have the skills and the tools to communicate that to the students that they serve. So with that in mind, training responsible employees is critical. And I talk about this a little bit in primary prevention and trainings when I'm talking about different populations to train. But just a couple of things to include in responsible employee trainings to make them particularly effective. Like I said, you have to train folks on how to talk about their status and what it means. Some folks who are designated responsible don't like the fact that they're designated responsible because they want that freedom to be able to support a student in the way that they see best, especially if it's somebody they're close with, especially if it is a student. So really being clear about when and how to share your status and exactly how to explain what it means. That it doesn't mean that that person shouldn't trust you. It doesn't mean that that person shouldn't disclose to you. It just means that you're going to share some of what they tell you with the Title IX office, just the basic facts, so that they can then have access to accurate options and resources. Of course, training on handling disclosures is important for responsible employee trainings. I think some basic information about trauma responses, I've seen that be particularly effective, especially when you're working with faculty or RAs, so that folks know that some of their preconceived expectations about how somebody is meant to, quote, respond to a trauma might not actually be accurate and might not fit with everybody, and that everybody's trauma responses are valid and are very different. So not to bring biases or expectations into an interaction with someone when they are disclosing to you. And then I also do think it is helpful to train folks on some basic reporting options and rights. Not to supersede at all the role of the Title IX office in sharing this information, but if somebody is disclosing to you and in that moment is kind of asking questions, just to have at least a little bit of a lay of the land, that there are options within Title IX, within the criminal legal system, and to receive medical care as well. Now, there might be a few changes to responsible employee designations if the new Title IX rule goes into effect in August of 2020. So make sure you are communicating and reaching out to your TA providers to clarify exactly what you should be doing and if anything needs to change. Similarly, school policies are going to become more and more important as schools change up their processes. So make sure you are communicating with your schools. If your Title IX coordinator partner is asking you who should be designated responsible on their campus, that is not a question that you should be answering. That is something they should decide internally with their Office of General Counsel. If they're asking you to train the people that are designated responsible, that's perfect. That's totally fine. And I kind of talk in community level strategies and strategic programming, as well as direct services, a little bit about knowing your role as the Enough is Enough provider to make sure that you are using your expertise in the best way possible, but are also protecting yourself. Because some of these Title IX cases can get really, really complex, particularly with some of the rules and regulations in flux at the moment. So I do want to talk about the Title IX rule of 2020, and with the caveat that I'm going to whiz through some of the main highlights just so that they are here. But given that I am recording this webinar in July of 2020, it is in the hope that the new rule will not be implemented as is. So if that is the case, then feel free to stop the webinar now and look back to some other there's so much information about Title IX, and there's a lot on the TTA website. So to familiarize yourself with Title IX protections through that as well. One last thing I'll say before folks sign off in case the 2020 rule isn't implemented is that there has been so much media focus and policy back and forth around Title IX, particularly in the last decade or so. And in that, usually the focus is on the process, on the reporting process, on whether it's an investigation or whether it's a hearing and what that hearing should look like. But I really want folks to remember that Title IX is not just about the reporting process. It's also about supportive measures. It's also about safety measures and resources. So I think that does get lost quite a bit, and that is sometimes a place in which the school might have a little bit more flexibility. So reminding any partners you're working with, or even students who are asking you questions about Title IX, that Title IX is not just about the reporting, it's also about the supports that students who have been impacted by sexual harm have the right to. So remembering that is I think really useful when kind of trying to juggle some of these challenges with Title IX and keeping one hand on both pillars, because they are equally important, although one is sometimes overlooked. So to talk a little bit about the new Title IX rule that was released in May and has an implementation date of August 14th, I mentioned that it might, that there are some legal challenges that have been put forward. There are some national groups, there are some states attorney generals that are working to prevent the Title IX rule of 2020 from going into effect. Make sure you are keeping a close eye on any news around this, and make sure that you are following any guidance that you're receiving from your TA center and also from the DOH on this topic as well. So really quickly, in case it is implemented as is, a few of the top lines. And like I said, there's a ton of information about the new Title IX rule for you to check out. I'm going to be as quick as possible. For folks who know me, they know that I can talk about Title IX all day, every day. So I'm going to try and limit that a little bit. So one of the main things that the rule does is to limit what an institution can respond to under Title IX. A quick caveat, for the purposes of brevity or attempted brevity, I'm just going to cover impacts on colleges and universities specifically in this new rule, not on K through 12 middle and high school students, although do not forget Title IX does apply to them too, and students before college age or before institutions of higher education do have a right to do have rights under Title IX, excuse me. So the new Title IX rule, if implemented, would limit what an institution can respond to in a few ways. Firstly, they have narrowed the definition of sexual harassment to 3 prongs: either quid pro quo sexual harassment by an employee. So that if that happens, that would be defined as sexual harassment under Title IX, and a school has to respond to it. If, however, a TA engages in quid pro quo sexual harassment for a grade, for example, or for threat of a score, that would not count, unfortunately, as that is not a faculty member employee. There are some questions about whether or not a part-time employee counts. Again, look out for any updates as they come. They've also changed the definition to unwelcome conduct that a reasonable person would find so severe and pervasive and objectively offensive that it denies a person equal educational access. Now, this is different to severe or pervasive because it essentially means that an incident of sexual harassment must be happening frequently and also must be severe, according to a reasonable person. This differs, for example, to the 2011 Dear Colleague letter definition of unwelcome conduct of a sexual nature. And so you can tell that it's kind of making the criteria narrower that an incident of harm must reach before a school must respond under Title IX. And thirdly, they do also include sexual assault as defined by the Cleary Act, which includes dating violence, domestic violence, stalking, and sexual assault, which they define by VAWA as rape, fondling, incest, and statutory rape. So with these incidents of harm, the severe and pervasive standard does not have to be reached. However, we know that a lot of the harassment that students are experiencing does not necessarily fall under one of these definitions. So there are concerns about this narrower definition limiting the students that will be able to seek support and resources through Title IX. They've also changed the actual knowledge standard. I'm going to go real quick through this, but essentially now the school is only considered to have actual knowledge if somebody is reported to that has the, quote, authority to institute corrective measures. So it's not somebody that the student might think, reasonably think has the authority to institute corrective measures or to do something about it. Essentially, the student would really need to report to the Title IX coordinator or somebody else with sanctioning or disciplinary authority in order for the school to be put on notice officially about the harm that has taken place. The geographic scope has also been limited in the new rule if it goes into effect, wherein now, whereas before, Title IX was based on affiliation with the institution, as I mentioned a little earlier. Now, only incidents that happen on campus or in a space where the school has substantial control over the respondent, the context of the incident, or in a building owned or controlled by an officially recognized student organization, only in those geographically limited spaces where incidents occur there, then the school must respond. If something occurs off campus, if something occurs during a study abroad program, if something occurs in a non-recognized Greek house, for example, then the school cannot respond under Title IX if this new rule goes into effect. This is concerning particularly for commuter students, particularly where most students are not residential or in cities. So again, think about how this impacts each school that you're working with, depending on your region and your community. And then finally, only a currently enrolled student can file a formal complaint under Title IX if this new rule goes into effect. So if somebody has taken time off due to harassment or graduated or transferred, then they would not be able to file a Title IX report with that institution where the incident of harm took place. So essentially, under the new rule, the school must investigate if a formal complaint has been made to the right person with authority to institute corrective measures of something that happened in the States on campus or in kind of one of these limited extra kind of geographic locations between people who attend the school, having met the now narrower definition. I'll talk a little bit later about how enough's enough plays into this, but the Title IX rule does say that if the school wants to investigate something that doesn't quote count, for example, under the new Title IX rule, they can do so under their own process. So if an institution says in their policy that even if something happened off campus, we will still pursue a student conduct process because committing sexual harm, even if it's off campus, does violate our student code of conduct, then that would be permissible. So really quickly to talk about the grievance procedures, there's a change in terms of evidence wherein now, if the rule goes into effect, all evidence gathered during an investigation that is directly related to the allegations raised in the complaint must be included in the information given to both parties and their advisors of choice, even if this evidence was not used in the determination of responsibility. So there are some concerns around privacy there, and also the school capacity to maintain all this evidence, collect it, and kind of parse through it. Additionally, whereas before an investigator model had been permitted, the new Title IX rule, if implemented as is, would mandate live cross-examination. It does say that if either party requests a separate room, that must be accommodated. However, cross-examination must be direct, oral, and in real time. It cannot be conducted by the individuals themselves, by the reporting or responding student or students. It must be conducted by the advisor of choice. However, there are very few limits on the types of questions that can be asked. There are some limitations around sexual history. Again, have a look with your TA providers about exactly what that means if you have been asked to support a student going through a case. The advisor of choice must now be the one to conduct cross-examination. So a student must have an advisor of choice. If they don't, then one will be appointed to them. But it can really be anyone. There aren't any limitations in the rule. So this is going to be really important for Enough is Enough coordinators who are asked to be advisors of choice. If that is the case, make sure you're working with your TA center, with your TA provider, to really figure out exactly what that means and how you need to be prepared for it. The 60-day timeline has been removed if the rule goes into effect, and it is stated that you can delay a Title IX process for a criminal process, which we know can take a very long time. And then also with standard of evidence, I'm not going to go into it now because it is a little bit complicated and not necessary for you to have a grasp on to start your EAE work. But again, if you are involved in a case, I did want to just pop it in there so that you can familiarize yourself with the standard of evidence that your school is using, whether that is preponderance or clear and convincing. Alrighty, I quickly want to talk about supportive measures as well, and I am skipping some elements in the new rule, but like I said, I just want to give kind of the main top line points. So supportive measures are now defined in the new rule, if implemented, as non-disciplinary and non-punitive. So they are designed to restore or preserve equal access to educational opportunities. So what that does mean that if you have a no contact order, for example, until there is a determination of responsibility, it would have to be non-disciplinary and non-punitive. So that likely means it would be a mutual no contact order. Again, that's something you would need to work with your school and work with your TA provider to familiarize yourself with. But it is important to know if you are supporting a student with identifying their options after experiencing sexual harm, that you are familiar with exactly what the supportive measures look like at their school in their policy. It does state, however, the new rule does state that a formal report is not required. And, you know, they do list examples of supportive measures such as course-related adjustments, the opportunity to retake classes or exams, opportunity to have counseling, deadline extension, modification of class schedule, changes in housing, and some of the safety measures that we've been familiar with for a while. The new rule, if implemented, also does allow mediation between student-on-student cases. And they do clarify, however, that the student may withdraw and resume a formal grievance process prior to agreeing to a resolution if they so choose. This is a change because in the past, mediation had not been permitted in cases of sexual harm. And then finally, there is a change to the religious exemption policy under Title IX. In the past, schools had to essentially notify the Department of Education if they wanted to claim religious exemption from any of the Title IX requirements. And if this new rule goes into effect, they could claim religious exemption after the fact, even if they have been reported for violating Title IX. If they then claim religious exemption, that would potentially not be considered too late to do so. So I include all of these top lines because I think it really is important for us to recognize the landscape that students are in as they're trying to make decisions about their options after experiencing sexual harm. Additionally, this has been covered in the newspaper a lot. There has been a lot of student organizing around it. So it's really important for you to be familiar with some of these histories so that you can support students who are maybe parsing through exactly what it means to be going to school in this time and to be figuring out what this means for them. Do not forget, however, that in New York State, we do have Enough's Enough 129B, and I'm going to talk about that in the next section. 129B has a lot of great additional protections that are really important, and it's critical more than ever for you to remind students when you're training them that not only do they have Title IX rights, but in New York, they also do have rights under Enough is Enough. And I have found that quite often students aren't as familiar with Enough is Enough as they are with Title IX. It just gets more press play, but I think it is important for you to remind students that they do have protections coming from a lot of different directions, including yourself and your agency and your Enough's Enough program, and to make sure that you are really kind of holding folks as they figure out what the best option is for them.